Thank you for this presentation. I just wanted to mention that in a PhD thesis that I supervised by Boaz Cohen, it was later published also, he showed that indeed the claims conference gave Yad Vashem during this first decade its half, but the State of Israel did not give its share of the budget. And the Ronnie. Yeah, okay, but so that is regarding funding and. So our next speaker will be Ovidiu Creangă. Dr. Creangă, who got his PhD from King's College in London, is a historian at the Conference on Jewish Material Claims Against Germany in New York. In this capacity, he supports ongoing efforts in the area of compensation for Shoah survivors, commemoration and restitution. He also coordinates the writing of the history of the Claims Conference and its compensation programs for a multi-volume series titled The Years in Compensation. Before joining the Claims Conference, he was a researcher at the United States Holocaust Memorial Museum, where he documented the fate of Jewish and Roma victims of persecution during the Shoah in Romania for the museum's Encyclopedia of Camps and Ghettos. We also, on a personal level, cooperated a lot in a project that I will mention in my closing remarks later on. He will talk also a long title, From Protocol 2 to Germany's Last Gesture, Legal Precedent, Uncompensated Shoah Survivors, and the Creation of the Hardship Fund in 1980. Ovi, here you are. And you will handle.
If I had known the state of my voice when I wrote this paper or before I came, I would have shortened the title and I would have shortened lots of everything else. Ladies and gentlemen, please forgive my voice. I feel absolutely fine. But a soccer game before leaving my home where my son was playing, and jet lag and a million other wonderful conversations since I got here has produced this incredible rusty voice. So just bear with me as I'm trying to make my way through this paper. I want to extend my thanks again, Professor Stamper, for this fantastic conference. I told him earlier that if he needs any evidence that this conference was so successful, you don't have to believe anything and say, just listen to my voice. And he said that he will provide me with some, what is it, Google Moogle solution. So if anybody has some Google Moogle, I will be willing to take it. Anything just to repair this. So with that as an introduction, let us go forward. The topic of my presentation today is about the Hardship Fund that was established in 1980 between Germany and the Claims Conference. And I have to say I benefited already from so many other discussions, including Dr. Wesley Fisher's presentation, which I think gives us some context to what I'm about to say. Established in the 1980, the Hardship Fund was the first and perhaps the longest fought-over compensation agreement concluded between Germany and the Claims Conference since the Luxembourg Agreement of 1952. The German government committed in Luxembourg to giving the Claims Conference a lump sum of 450 million Deutschmarks for assisting Jewish Shoah survivors outside Israel. This global payment, enshrined in Protocol 2 of the Luxembourg Agreement, was, in the words of the Claims Conference President, Dr. Naum Goldman, truly revolutionary. Its chief importance, beyond the financial aspect, being that, and I quote, it establishes a precedent of major significance for the future, end of quote. Yet Protocol 2's impact on subsequent agreements between Germany and the Claims Conference has remained largely unexplored. Has the Protocol 2 agreement ever served as a precedent to conclude later agreements? In this short paper, I seek to demonstrate that the conference not only used Protocol 2 as a legal precedent to frame the Hardship Fund agreement, but that it proposed terms for the Hardship Fund that closely resembled those of Protocol 2. Germany's repudiation of this framework in favor of an entirely different agreement, an agreement that forever changed the nature of the Claims Conference, is discussed in the conclusion of this paper. Negotiating after negotiations. As Carol Fink has aptly observed, the creation of the Hardship Fund entailed negotiating after negotiations. The expansion of the German federal indemnification legislation of 1965, coupled with hundreds of millions more Deutschmarks spent in global agreements with Western countries and payments to Central European countries for victims of pseudo-medical experiments, had dampened German sentiment toward Jewish Holocaust survivors streaming into the West from behind the Iron Curtain after 1965. German expenditure and fulfillment of the Luxembourg Agreement commitments grew by 1977 to over 61 billion Deutschmarks, further complicating the prospect of a new agreement. Numbering into tens of thousands, these Eastern European Jewish survivors would have applied for German compensation had they not inadvertently missed a series of deadlines set by Germany. As a result, they were excluded from federal compensation through no fault of their own. Like the earlier wave of Jewish Holocaust survivors hailing from Eastern Europe, namely the so-called post-1953 group, those emigrating after 1965 represented an ongoing problem for both Germany and the Claims Conference. As early as 1953, Germany started arguing that in Protocol 2, it had provided money for the needy survivors uncovered by the indemnification program and should not be asked to do more. The conference rejected from the beginning the notion that it accepted the Protocol 2 money, the 450 million Deutschmarks, as a fund to meet individual compensation claims inadequately covered under existing German legislation. It also stressed its organizational limitations in handling large volumes of individual claims. Thank you so much. Is this the Shmuga Google? No, a version of it? Okay. Shmuga Google. Great. Google. Okay. Cool. Germany is saying that basically we provided money for needy survivors in the Protocol 2 fund. The conference rejected from the beginning the notion that it accepted the Protocol 2 money as a fund to meet individual compensation claims inadequately covered under existing German legislation, and also stressed its organizational limitations in handling large volumes of individual claims. In the Claims Conference's view, the moral, if not legal, obligation to compensate the post-1965 survivors rested with Germany alone. The Claims Conference's attitude had for years enraged German officials at the federal and Länder levels. It equally infuriated Jewish organizations in Germany, whose demands for money from the Protocol 2 fund for assisting their needy Shoah survivor members went unheeded. Understandably, frustrated survivors wrote the German Ministry of Finance complaining that they received no financial assistance from the Claims Conference. In response to pressure, Germany amended the 1965 Federal Indemnification Law, the BEG, to offer limited benefits to the survivors who had emigrated to the West before 1965. But it categorically refused to extend those benefits to those escaping after 1965 from places like Romania, Poland, Czechoslovakia, and the Soviet Union. That law was final. The Claims Conference allocated considerable sums for emergency aid and immigration assistance to the post-1953 group from its Protocol 2 fund. But by the mid-60s, most of the Protocol 2 money had been allocated or was earmarked for contractual obligations, and therefore the conference was in no financial position to assume responsibility for the post-1965 group. Thus, given the conference's lack of discretionary funds and Germany's refusal to reopen the BG, the conference had no choice but to urge Germany to alleviate the needs of these uncompensated Jewish Shoah survivors. And indeed, in 1972, the conference formally submitted to the German government a list of demands, calling, among other things, for the creation, and I quote, of a special fund for post-1965 migrants, Nazi victims, who took their departure from Eastern Europe before December 31st, 1965. Carol Fink and Marilyn Henry, and including Rachel Blumenthal, who is here in this room with us, have provided valuable accounts of the lengthy negotiations between the conference and Germany over the Hardship Fund. Their accounts, however, do not examine the role of Protocol 2 agreement in shaping the Claims Conference's approach to the Hardship Fund. As such, the use of this legal precedent in the extensive negotiations for the new fund has remained unknown. Protocol 2, Article 2 of the Luxembourg Agreement permitted the conference alone to set priorities of spending. It stipulated that the amounts Germany paid to the Claims Conference, I quote, will be used for the relief, rehabilitation, and resettlement of Jewish victims of National Socialist persecution according to the urgency of their needs as determined by the conference. By drawing inspiration from this article of Protocol 2, the conference sought to secure a new agreement for the Hardship Fund that would allow it once again to decide how to spend the funds on uncompensated survivors without interference from the German government. But what did the conference determine the survivors' urgency of need to be in 1978, when negotiations drew near the end? And how did it go about ensuring that it has the freedom to allocate solely according to its judgment? Naum Goldman, the Hardship Fund's chief negotiator, envisioned in December 1977 spending less than a third of the anticipated 540 million Deutschmarks, as was offered in 1977, on survivor relief. Being a legacy-driven character, and this is very important to stress, being a legacy-driven character, Naum Goldman thought that more than two-thirds of the fund should go to the Memorial Foundation for Jewish Culture for distribution to the Museum for the Diaspora in Tel Aviv, the building where we are today. The establishment of an endowed chair in Jewish Studies at Heidelberg University in Germany, and for programs to combat anti-Semitism. He presented this spending proposal to the German State Minister Hans-Jürgen Wisniewski during their meeting on December 20, 1977. The proposal quickly attracted the gentle critique of Saul Kagan, the conference's executive director, who warned Goldman against allocating too little for the survivors' relief needs, saying, and I quote, "Don't you think it may appear strange and possibly be used as an argument against the urgency of the entire proposal that we are playing down the importance of the individual beneficiaries of the fund by reserving less than 25% of the total for that purpose?" Goldman eventually acquiesced to Keegan's call for higher relief spending, thus underscoring the conference's assumption that it would be allowed to determine the fund's distribution, as was true in Protocol 2. Wisniewski, representing the ruling Social Democratic Party in the governing coalition, allowed that much to be understood by not commenting on Goldman's allocation plan. He focused instead on the need for Goldman to secure the support of the two other parliamentary parties, particularly the backing of the opposition Christian Democratic Union, CDU, for a bill needed to pay for the new fund. From Protocol 2 to Protocol 3, finding the right legal tool to ensure the Claims Conference controlled the spending of the fund turned out to be an engineering matter that played well to the strengths of Saul Kagan. Keegan gained the reputation of someone who could turn Goldman's grand designs into reality. Unsurprisingly then, it was Keegan who recommended in the summer of 1978 that Goldman seek from the German government the closing of a new protocol resembling Protocol 2. Keegan called this pact Protocol Number 3. In a confidential letter to Goldman dated August 15, 1978, Keegan admitted, and I quote, giving a great deal of thought to the formulation of the agreement which you expect to reach with Schmidt, Kohl, Genscher, and Strauss. Since the terms, these are all highly influential characters, future chancellors, existing chancellors, future chancellors, and presidents of the state minister presidents of Bavaria. Since the terms of the agreement had yet to be formulated, Keegan wrote Goldman, "It is important for you to be ready with a document of your own before they come forward with their drafts. I therefore suggest that you propose the signing of a Protocol 3, which would follow the format of Protocol 2, signed in Luxembourg by you and Dr. Adenauer on September the 10th, 1952, covering the payment of 450 million Deutsche Marks to the Claims Conference." Now, modeling Protocol 3 after Protocol 2 would produce, in Keegan's words, a very brief document that provides for the modus of payment, reporting requirements, and a mechanism to deal with disputes. Beyond its simplicity and clear procedures, however, casting the Hardship Fund agreement, as was conceived at that point, after the Protocol 2 terms, guaranteed the Claims Conference's independence and allocation. And I quote, "The crucial language from our point of view," wrote Keegan, "was the right of the Claims Conference to decide on the distribution of the funds." Building on precedent was another feature Keegan highlighted in his proposal for the new pact, telling Goldman, "The suggestion that your new agreement should take the form of a Protocol 3 should appeal to the German political leadership, for it follows a precedent which the same political parties approved in the past, and it enables them to draw a Schlussstrich under the entire subject without involving them in the future." Keegan appended a copy of Protocol 2 and the first draft of Protocol 3 to his 1978 letter to Goldman. And here you have the first draft of the so-called Protocol number 3. The two protocols, the original Protocol 2 and the drafted Protocol number 3, shared a great deal of language and phraseology. They differ substantially in the explicit addition of cultural investments to the use of the Hardship Fund, which of course was a significant change from Protocol 2. The conference's wish to decide alone the allocation of the anticipated funds was penned down in this first version of Protocol 3, Article 2 as follows. The amounts paid to the conference on Jewish material claims against Germany will be used for A. Jewish victims of National Socialist persecution who are largely and totally excluded from the benefits of existing German indemnification legislation, in accordance with their urgency of needs as determined by the conference. And B, for projects designed to restore and replenish Jewish cultural values and resources destroyed by National Socialism. Keegan stated the two areas of distribution, relief and culture, in broad enough terms to allow the conference not only to determine priorities in welfare spending, but also to make block payments to the Memorial Foundation, as well as for specific projects for which Dr. Goldman had prior commitments. In terms of percentages, this Protocol 3 version envisions spending 60% of the 600 or 540 million that was discussed at that point on welfare and 40% on cultural projects. The agreement with Germany was thought to be reached by the end of 1978 and payments to begin in April 1979. Yet another year had passed before negotiations advanced towards the finish line. Eyeing a potential conclusion by the end of 1979, Keegan wrote Goldman again in September of that year with information on the likely number of beneficiaries for the new fund. He again emphasized that Goldman should seek from the Chancellor's Cabinet an agreement that the funds be paid to the Claims Conference, and I quote, analogous to the Hague Protocol 2, end of quote. Attorney Ernst Katzenstein, the Claims Conference representative in Germany, revised Keegan's Protocol 3 draft and produced a more lawyered version, which indicates that the notion of a Hardship Fund agreement resembling Protocol 2 was still operational in 1979. And here you have Katzenstein's revision or revised version of Keegan's version. Katzenstein's version of Protocol 3, which Keegan also showed Goldman, made no indication of how the conference was to divide the money between the approximately 75,000 post-1965 Holocaust survivors presumed eligible for the fund and the conference's cultural and educational projects. "I leave this to you," said Keegan, "as you are the father of this fund." We're moving now to the next section called a Hardship Fund Agreement without Protocol 2. The proposal for a final redress gesture toward Jewish Nazi victims was introduced in the Bundestag session of December 14, 1979. The 440 million spending fund was designed the 440 million spending fund was designed to compensate individual needy Jewish victims who were ineligible for the BEG indemnification because they arrived in the West after 1965. Thanks to Goldman's assiduous work leading up to that date, the bill for the new fund enjoyed broad political support. Yet, few German parliamentarians accepted Goldman's spending proposal. So the resolution that emerged from the Bundestag drastically reduced the conference's freedom to allocate funds beyond welfare. Shortly after this became clear, on December 27, 1979, a relentless Keegan telegraphed Goldman saying, "After review of December 14 Bundestag resolution signed by Kohl, Zimmermann, Wegner, and Michnik, I believe your major problem will be to persuade CDU, CSU to modify limitation on the use of funds which are restricted in the resolution to compensate," this is the citation in the resolution, "to compensate for hardship in individual cases. In this connection, I suggest you stress Hague Protocol 2 precedent, wherein federal government agreed and Bundestag ratified provision that the 450 million Deutschmarks be distributed by the Claims Conference for relief, rehabilitation, and resettlement of Jewish victims of national persecution in accordance with urgency of their need as determined by the Claims Conference. From the start," and this is still part of the same citation, from the start in 1954, Claims Conference allocated portions of funds for cultural programs. Approximately 15% of the conference allocations went for cultural activities as part of the rehabilitation of Jewish communities and cultural life destroyed by Nazis. Would rather urge German government should adhere to the Hague precedent and place responsibility upon Claims Conference for distribution of funds and establishment of priorities and criteria for individual hardship payments. These are very complex internal Jewish problems which Bundestag would be advised to avoid. And I think we would still agree with that. It is clear from Keegan's response, end of quote. It is clear from Keegan's response that the diversion of money for cultural allocations had become a sticky point for German officials. In his formal reply to the December 14 Bundestag resolution, Goldman carefully avoided confronting the Germans over cultural allocation. He mentioned in this regard only that it would be to the advantage of the federal government to let the Claims Conference decide how to distribute the funds, thereby avoiding criticism and additional demands. As a precedent, he concluded in his letter, I quote the text of the agreement between the federal government and the Claims Conference after the conclusion of the negotiations at The Hague. There it was determined that the sum made available to the Claims Conference should be used for relief, rehabilitation, and resettlement of Jewish victims of Nazi persecution in accordance with urgency of their need as determined by the Claims Conference. The following months, end of quote, the following months saw a few more meetings between Goldman and German officials, but the Protocol 3 language, namely compensation for the uncompensated and cultural investments, gradually gave way to Germany's framing the fund after its BG language of damage to health, leading to hardship in individual cases. The German cabinet decided at its meeting on July 25, 1980, the division of the 400 million Deutschmarks fund between the Claims Conference, which was to receive 400 million of that fund, and the Zentralrat in Germany, who was to receive 40 million. and earmarked another 5% from the conference's share for spending on institutions offering services to the survivors. The agreement provided no money for cultural spending, which clearly departed from Goldman's vision for the fund. It also made it a precondition that the claims conference administers the payments, which was a clear departure from the conference's vision of having the freedom to determine the allocation, not to administer payments. Nevertheless, the claims conference accepted the terms half-heartedly, and Chancellor Helmut Schmidt signed the agreement in Bonn on October 3, 1980. A day before the publication of the fund's guidelines in the Federal Gazette, which was scheduled for October 14, 1980, Katzenstein met with the Finance Ministry Director, Dr. Bruno Schmidt-Bleibtreu, to clarify the terms of the new fund, which the claims conference was to administer under German guidelines. It emerged during their discussion that the German officials had decided to strike down the use of the Protocol 2 as a framework for the Hardship Fund. There will be no reinstatement of the Hague Protocol 2, wrote Katzenstein in his minutes of the October 13 meeting at the Ministry of Finance. According to Schmidt-Bleibtreu, this was because groups of persecuted Jews from around the world had written letters of protest to the German government, to the federal government, This was because groups of persecuted Jews from around the world had written letters of protest to the federal government that these provisions had not, as intended, gone primarily to individual persecuted Jews, but rather to Jewish organizations. End of quote. Consequently, in another quote, all parties involved, the federal government, parliament, and parties, had jointly expressed the view that there could be no repetition of the determination on the issue stated in the Hague Protocol No. 2, by which the claims conference could allocate funds according to its judgment. End of quote. With that decision, the German government put to rest its frustration with the conference over its use of Protocol 2 money. So in conclusion, the Protocol 2 agreement remains singular in the history of negotiations between Germany and the claims conference. The conference tried and failed in its attempt to frame the Hardship Fund agreement after Protocol 2. Germany's refusal to allow the claims conference to decide the allocation of the Hardship Fund constituted the key departure from Protocol 2. Even so, the Hardship Fund agreement was historic and set a precedent of its own. Beyond the fact that it transformed the claims conference into a global payment processing and payment distribution organization, it also established a format that shaped subsequent compensation funds. All the major compensation programs that the conference administers today are informed by German guidelines. This principle still holds, even when negotiations between the conference and Germany result in expansions to a fund's initial terms. Thanks to these negotiations, the Hardship Fund to date has benefited over 500,000 survivors, nearly 7 times the number estimated in 1980, and has paid out more than $1.4 billion, far beyond the initial sum of 400 million Deutschmarks. If the signing of Protocol 2 birthed the claims conference into existence, the conclusion of the Hardship Fund agreement extended its life well into the future. Thank you very much.